All right, it's just turned 7. We'll pick it up in just a minute or two. All right, we've used up our usual couple-minute buffer. So let's go ahead and get down to our quick review and then new material. So we are picking up from where I believe we left off, which is chapter 10 of Yevamot and Mishnah number 1. Now we got about halfway through this Mishnah. If you scroll back to the beginning, you'll be reminded that we are talking about the case where a husband had been overseas. Then there was a witness that he had died, and through one reason or another, for the moment, we're not going to go into much more detail than that, the woman remarried off that testimony, but then it turned out that it was incorrect, that the husband was in fact alive. He returns, and she has to separate from both her first husband, the one she thought was dead, as well as from the second husband, the one that she had married afterwards, because you can't be married to two husbands. And because the marriage to the second was illegitimate, therefore, she is now disqualified from both of them, and the children from that second marriage are considered to be illegitimate as well. And if she were to have children from her first husband, after all of this had happened, those two would be considered illegitimate. Now, we're going to pick up with some of the other implications of this tragic scenario. Now, this wasn't a common case in the sense that it wasn't that husbands were constantly disappearing overseas and witnesses were coming to explain about their death, but it also wasn't entirely uncommon. The phrase overseas is sort of the technical jargon used in rabbinic literature for the husband having been in a dangerous situation, and there was then some evidence that he had died. I know many of us take traveling overseas for granted, or at least we did take it for granted before COVID locked us down. But in the ancient world, traveling overseas was basically the equivalent of saying he went somewhere risky. So there is an additional reason to believe the witness when he says he's dead. If the witness had just shown up and said, oh, by the way, your husband was out in the field this morning and he died, the reaction would be very different. But because it was an overseas trip, then there wasn't any surprise that he had died. People died in that kind of situation all the time, unfortunately. So with that in mind, when we continue to bump up into the they were overseas, they were overseas, they were overseas, a theme that's going to continue in many of the rest of the Mishnayot, don't be surprised, because it's trying to describe this merely as a stand-in for dangerous situation. This is why, just as one little aside, on top of another aside, this is why we do Gomel, the special blessing for recovering from a dangerous situation when returning from a dangerous trip. Now, in the classic world, really until the modern times, a person would bench Gomel, as we say. They would say the blessing of Gomel anytime they returned from an overseas trip, because every trip was considered to be perilous. Nowadays, it's usually only if something dangerous happened during the trip that was unexpected that will prompt a person to say gomel. Usually we do it now when a person has recovered from a serious and dangerous illness.
And what happened, Rabbi, during the time of the Second Intifada? That was coffee shops and restaurant blowing all the time in Jerusalem. Can you say at the time Gomer? Because
of course.
You went to Israel and really, literally, your life was dangerous.
Absolutely. There was there's no rule saying that you couldn't bench gomel from just flying, between San Diego and Los Angeles, even though it's a short trip and there aren't a lot of crashes or anything. If you feel that it is dangerous, there is no reason not to allow a person to bench gomel. And certainly during the intifadas, if a person wanted to bench gomel, that was something that would be approved of. And especially as we're here at the end of Yom HaZikaron, when we remember people who were killed in the wars of Israel, as well as those killed by terrorists, it's important to remember that level of danger that has been in Israel for far too many years during its existence. On a personal note, when I went to Israel for rabbinic school in 2000 and what was that? 2002, I think 2003. Yes, 2003. The second intifada was still going very strong, and the day after I arrived, I'm trying to remember the exact timeline because I went a few weeks earlier than Penelope and Hannah, who was a baby at the time, in order to secure and set up the apartment. There was a bombing just a couple blocks away from the apartment. And one of my colleagues, who was also there for rabbinic school, had just left the cafe before it exploded. He was just down the street, having walked out of the doors when it blew up behind him. And absolutely, all of us were very much on edge, just as everybody who lived in Israel 24/7 was on edge. And saying gomel after taking a bus trip would have been entirely reasonable during that time, given how frequently the buses were attacked. All right, so from that unfortunate circumstance to the unfortunate circumstances that we deal with in our Mishnah. So we're dealing with this situation where she has two sort of husbands that she's had to be divorced from, but it may not be done yet. The divorces may not have been finalized, the get not delivered. And in the meantime, she's kind of got two husbands. So the question is, what is her status to the first? What is her status to the second in relationship to many other topics of husband-wife relationship? So we're going to run through a range of possible issues and see what her status is. So, and neither this man nor that man, meaning neither the original husband nor the second husband, may become impure for her upon her death if they are priests. You will recall that a Kohen, a priest, is only allowed to become ritually impure by taking care of the dead body and participating in the funeral for one of the immediate relatives, parent, sibling, children, or spouse. In this case, even though she is still technically a spouse, because of the issue, she is not spouse enough for him to be given permission to become ritually impure should she die while they are still connected in this messed up way. And neither this one nor that one is entitled to the rights that stem from the marriage bond. What are some of those? Neither to her found articles, nor to her earnings, nor to the nullification of her vows. I'll explain each in turn. According to rabbinic law, if a woman finds a lost article, she is walking down the street and she comes across a $10 bill. As we see in the Bavas, that is a lost item that cannot be returned to an owner. There's no siman, there's no sign on it, there's no way to claim it. Obviously, if you see it fall out of a person's pocket, you have to return it. But we're talking about just floating in the wind, $10 bill. Technically, it belongs to whoever takes possession of it first. However, the rabbis instituted that while married, the woman's husband would have a claim on anything that she found, that it wouldn't become her, or wouldn't stay her property, but would instead become the family property, meaning under his jurisdiction. Now, that was an law instituted in order to prevent anger and stress within the family. And so with the family situation being such a mess at this point, neither husband is allowed to claim any property that she finds. Instead, it is her property, and it stays as her property, even as everything else is being dissolved around her. So too, the woman's labor is something that a husband has the right to claim. And in the ancient world, that was because he had an obligation to her for providing. So if he is providing, she has to also do work, and he is allowed to benefit from her work. In this case, because of the separation underway, she is not benefiting from him, therefore he does not benefit from her. Likewise, the nullification of vows, the husband, according to rabbinic interpretation, was only given permission to nullify a vow, and even then only immediately upon hearing it. He couldn't do it later, because there was the danger that she would make a vow that would make her have difficulty with him, that this could set up interpersonal conflicts that the husband would be extremely displeased with. And so there was a small window of opportunity for him to nullify such vows. However, during this period, even though they are still married because of the mess, neither husband is allowed to nullify one of her vows. Is everyone following those 3 points?
So if she does a vow, no one can nullify because she has like two husbands at the same time.
Well, yeah, she has both 2 husbands and no husbands. She has 2 husbands, neither of whom is legitimate, and therefore neither of them has a claim over her. All right. Now, if she was a regular Israelite woman and she had this situation, then she is disqualified from marrying into the priesthood, as her intercourse with the second husband is considered an act of illicit sexual relations. And as we've talked about before, that makes a woman ineligible, if it happens in this technical sort of way, to then marry into the Kohanic clan. And the daughter of a Levite is disqualified from partaking of the first tithe, and the daughter of a priest is disqualified from partaking of truma. Now, the tithing prohibition is a rabbinic prohibition as a way to put a limit to this type of behavior. The truma is more based within the Torah itself of the daughters of the Kohanim have this added stringency of their behavior expectations. Okay. Let me just scroll down as we reach to the end of these different issues. And neither the heirs of this man nor the heirs of that one inherit her marriage contract, her ketubah, as she is not considered married to either of them. This clause will be explained in the Gemara. So yes, this is the short way of saying it's complicated. But as we've talked about before, when in discussing different issues in Masechet Nashim of this portion of the Mishnah, generally speaking, if a woman happens to die before her husband, her children have the right to inherit the ketubah in honor of their mother. And this is saying that in this situation, no, they don't. That if she were to die before the divorce has happened, that her children would not be allowed to inherit the ketubah. It's a little bit more complicated than that, but that's why we have the Talmud to go into the more in-depth discussions of some of these points of the Mishnah.
So, Rabbi, if she's married to someone and she passed away before the husband, the children can request the ketubah?
Yes.
Really? But they receive anyway the money from heresy.
But there may be more than one child coming from more than one mother. So this would be a way of saying, look, our mother, remembering in the ancient world, ketubahs were bargained and negotiated. Our mother secured X, Y, and Z. Our mother brought X, Y, and Z property into the marriage. Therefore, when our father dies, we should be given certain special consideration as a creditor to the estate. in addition to the inheritance that we are going to receive.
So they can receive like a bigger portion on the other siblings.
Right. Well, they're not receiving, I mean, in the end, it's a bigger portion, but they're not receiving a portion. They're receiving the debt that the father owed to their family.
But that means they receive the directly portion as a sons. But after that, also in addition, they receive from
The father,
not from the establishment, from the
estate.
From the state. Thank you. I couldn't
Yes.
remember the term. From the state, also some money from the ketubah from the mom when the dad pass away. But can they request the ketubah when the dad is still alive if the mom pass away?
Wow. See, all these issues that haven't come up in my practical rabbinics. I'm trying to remember back to rabbinic school. You know, I'm going to have to put I'm not sure on that one. That when the father was still alive, but the mother has passed away, do they inherit? Can they request that the ketubah be paid out, cashed out immediately?
Correct.
I have to double check that. The negotiation of ketubahs is now no longer done in most communities, and the payout of a ketubah is also no longer done. But there's a general stipulation that the settlement in case of divorce or death will be handled according to local law and custom, in which case we handle it by American courts. So this is not one that I've had to practically adjudicate, and so only have vague memories of it in rabbinic from rabbinic school.
Okay. You have a homework now.
Yeah. And you know what? On the whole, I'm not entirely unhappy that I don't have to do this as a weekly event. Because these types of arguments can tear families apart. It's one of the reasons why the rabbis went to such lengths to make things clear, so that there would not be as much room for lawsuits over this sort of thing. Yes, a person could claim, they could go to court, but it would be settled and everyone would respect the law because it was very clear and detailed about these issues.
Rabbi, but just out of curiosity, though, wouldn't the heirs step into the shoes of the mother when she passed away? So just as the mother could claim the ketubah upon divorce, wouldn't they be able to claim it the same way upon her death?
Well, and that's what I'm saying is possibly, yes. That's why I can't say, 100%. On the one hand, it's technically only meant to be claimed when divorced or the husband dies. And as he is still alive, if she were alive, she would have no way to claim it unless he divorced her. And since she is dead, he can't divorce her. So would they have a way to ask for it to be cashed out? That I'm not 100% sure that they can. I know that they inherit the right to the ketubah, but my remembrance, which may be faulty, is telling me they only get it when he dies. But I'm not 100% sure on that because it's been so long since I studied this.
What happens if there's an court they decided because you say that now is going by local law, okay? And what happens if you are unhappy with the decision? Can you sue the Jewish court?
For issues that are handled in American courts, no. Once the litigants agree to accept the decision of a court as binding, then they do not get to challenge it in another court. Now, that is something that can be overruled in a couple of circumstances. If the American court does not consider a certain aspect that is important in Jewish law, for example, the giving of a get, then you can sometimes appeal to a Jewish court to secure the get if the American court will not rule on that topic. And it depends on the state of how much they want to get involved in those issues. Additionally, in Jewish law, there is some provision if the non-Jewish court was a court that acted illegitimately, meaning that you were dragged into that court by a Jewish litigant, but you did not agree to its jurisdiction or standing, but the non-Jewish court had leverage that forced you to stand in front of it. in that case, you can sometimes appeal to the Jewish court because there was never any reason for you to be in that court in the first place. But under American law, most people knowingly and willingly seek redress to these issues under American law. And so, to the best of my knowledge, Jewish courts are very, very reluctant to overturn those decisions.
But if you want to do that, need to be with agreement of both parts.
Well, again, if you're in an area where the Jewish courts are authorized to levy fines and force compliance, then you don't, because that is the law, that is the court. Take for example, imagine you and your business partner were in Rome and in the ancient world, and some deal happened between you that went sour, and he decided to make the Roman courts make a ruling on this. You're unhappy with this. The ruling is definitely contrary to Jewish law, for example. When you get back to Israel, you can go to the Jewish Beit Din, and they can force him to then stand before the Beit Din and re-adjudicate the case.
Rabbi.
But for most of our history, we haven't had that kind of leverage.
Rabbi.
Yes.
Before were you saying that the estate doesn't get cashed out potentially till the husband dies?
For a normal ketubah, for a normal wife in a normal circumstance, which doesn't apply to any aspect of this particular Mishnah, the woman only gets the ketubah under two conditions. Two and a half. One, she is divorced, and which point he pays out, or two, he dies, in which point his estate pays out.
Right.
The second point 2a can be technically, there is a way for a husband to buy out the ketubah in advance. Basically, he can cash out her debt by usually paying a lesser amount. Now, that's generally not considered good, and it's frowned upon, because oftentimes the husband can coerce the wife into accepting that arrangement. But it is technically possible, but under most circumstances, the rabbis do not allow it.
Right. But at any time when the ketubah is not cashed out, in that example, if it didn't get cashed out, are the heirs entitled to maintenance?
Yes. I mean, we went through that when we looked at the obligations between husband and wife when we studied that earlier.
Right.
So yes, if it's not been cashed out, meaning he died, the ketubah is still in the possession of
what
the
about
estate.
if she died? If she died and it's a pending debt, would they be entitled to maintenance from her ketubah if she died?
Not maintenance per se, but they are the children of the estate. So they would be entitled to maintenance by the estate if they are minors. And until the estate has been settled, they are provided for.
Oh, so as adults, I thought they're still entitled to maintenance. Certain people were entitled to maintenance by the state
until the estate has been settled. Yes.
Settled, yeah.
But once the estate's been settled, which would include the settling of the debts of the estate, namely the ketubah, then the estate is done and it's been transferred into the hands of the heirs.
But it wouldn't be settled till he died, potentially.
Yeah, you don't settle an estate until there's actually a death.
No. If she died, her estate wouldn't be settled till he died.
Correct.
All right.
Because the husband can inherit in many complicated ways from the wife, but the wife does not inherit from the husband. And again, all of that could be stipulated in much more detail. This is the default. So they can make special arrangements so that her money couldn't be inherited by him and vice versa. But that's all up to the individual arrangements that they would like to set as conditions before marriage, what we would call in the modern world a prenuptial agreement. All right, and final condition that needs to be reconciled before we hear some dissenting opinions. And if they both died childless, meaning husband one and husband two, the brothers of this one and the brothers of this one must perform chalitza, and they do not enter into levirate marriage. Because she is not legitimately married to either husband, but kind of married to both of them, then she, as the widow, has to be available for chalitza, and meaning they can only do chalitza in order to dissolve the relationship that spontaneously forms between her and the brothers-in-law when her two mostly illegitimate husbands die. But because they are mostly illegitimate, then there needs to be chalitza rather than yibum, rather than levirate marriage.
Yeah, because she can't marry both brothers also, so there's not any other way than doing chalitza.
Yes, if you did chalitza for one brother, you would be preventing chalitza for the, or if you did yibum for one brother, you'd be preventing yibum for the other, because she can't have two husbands. That's how she got in this mess. All right, now we're going to hear some dissenting opinions. I'll just tell you in advance, all of the minority opinions here lose. But as we talked from Ediot, we always preserve the minority opinions. Yes.
I just wonder if we could clear something up. Does that previous Mishnah that we talked about, does it assume those are two marriages, or does it assume that there's only one marriage because the second one's invalid? Because I know they discussed that a little bit, and they didn't clarify whether or not these were going off of one's invalid or there's two marriages.
So it is ish, right? So it is ish, right? One was, they were both married in the sense that they both went through kiddushin. They both went through the marriage process. And they were both married in the sense that both were married under good faith. Now, technically, yes, the second marriage was adultery rather than marriage, because the husband was still living and she got married under questionable circumstances. So that definitely makes the second marriage not a true marriage. However, because of the marriage-ishness of it, that is why chalitza is still required here in order to overcome that issue.
And is that partly taken from the Code of Justinia?
I have no idea.
Oh.
So of all of my studies, while I'm aware of Justinian's code and some of its contents, I cannot say that I am an expert in that, and so I can't compare.
All right, I just thought the USCJ cited to one of the Roman laws codes.
They might, and in fact, I didn't review that today. So if they did, that's great, and thank you for bringing it. But I didn't actually look at the USCJ commentary for today's class. That's one of the sources I use, but I don't use it every time. All right, Rabbi Elazar, he wants to have his own opinion. Sorry, Rabbi Yossi, have to do it in order. Rabbi Yossi disagrees with the first Tana, meaning the primary voice that we just heard, and says that she does receive payment of her marriage contract, and the obligation of her marriage contract is upon the property of her first husband. So Rabbi Yossi says, look, the second marriage, absolutely illegitimate. It can't work because she was technically still married. But she was technically still married, and therefore she should receive the ketubah from that first husband. So as you can see, there is logic behind his position. However, as we talked about last week, the renunciation of the ketubah, or the nullification of the ketubah, probably a better technical term, is part of the damage from this whole escapade. So while yes, technically it might make some sense, as the ketubah is a rabbinically ordained contract, and as this has now been a violation of not only Torah, but also rabbinic propriety, therefore the rabbis are within their power, within their authority to say no, that this is nullified and she does not collect her ketubah. Rabbi Elazar says the first husband is entitled to her found articles, to her earnings, and the nullification of vows. Since her second marriage was an error, the first husband does not forfeit his rights. So again, Rabbi Elazar is saying, yeah, second marriage wasn't really real, so that means the first husband still has all of the benefits. However, what's that?
Kind of agree with Rabbi Yehuda.
Well, we haven't got to Rabbi Yehuda. You mean Rabbi Elazar?
Rabbi Yossi, sorry.
Right. I mean, like I said, there is logic to all of these positions.
No, but the agreement between them, Rabbi Yossi and Rabbi Eliezer, both believe that the first marriage is much stronger, more real than the second one.
Absolutely.
So the first one received all the benefits.
But the rabbis instituted that there would be a complete dissolution as a form of damage, of punishment for the whole situation. And although Rabbi Elazar says, well, but that doesn't mean he should lose things that are his benefit, the rabbis disagree and say, no, no, no. We are dissolving all of this, right? This is a cluster bomb destruction of both marriages. And therefore, even though technically the first marriage has more standing than the second, we are wiping it all out. So again, Rabbi Elazar has a good logical argument to make, but the rabbis have pushed the nuke button, and they've said as a group that the majority says we are wiping out both marriages down to the ground.
When you say that as a group, meaning through the Sanhedrin or
Exactly.
or through the schools, the different schools?
Gam v'gam, it's the same. The Sanhedrin represents the final arbitration of laws that are in doubt, and it is then taught through the yeshivot, the academies, in order that it be perpetuated and persist, as that is the accepted ruling. Some individual teachers would remember their own tradition, which is what we're seeing here from Rabbi Yossi, Rabbi Elazar, and later on Rabbi Shimon. But that is, those were minority opinions that were kept, as we mentioned, for clarity as well as to rule them out, so that some brilliant person in the 21st century can't show up with the argument of saying, but, I think the rabbis probably didn't consider that the first marriage has more standing, therefore it should be ba 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 ba. We can open up to chapter 10 and show them, the rabbis talked about it, and that opinion lost.
Rabbi.
Yes.
God, I forgot what I was going to say.
It gives me a chance to lubricate the vocal cords. It's okay.
Oh yeah, what did you about punishment? You said it was being dissolved as a form of punishment?
Basically, the feeling is that this whole situation has created a impossible form. Additionally, what the rabbis were considering was the possibility that the first husband would be trying to take back the wife, that he would want to reestablish the relationship, that he would want to reestablish his claims over her as his wife, which is inappropriate. Because of the adultery, he is supposed to dissolve that relationship completely. So if he is trying to have claim to her earnings, to her found articles, to the nullification of her vows, then he is trying to exercise authority, which he should not be. And therefore, the general situation is none of it. Just hands off. We are done with this relationship because of the mess. Rabbi Shimon says an even more far-reaching ruling. Her sexual relations or her chalitza with the brothers of the first husband exempts her rival wife, as it is considered a proper levirate marriage or chalitza. And certainly she does not require chalitza from the brother of the second husband. So again, he's following the same logic that the second one wasn't a real husband. Therefore, a chalitza with the first husband for his brothers would exempt the rival wives, and it would be just as if she was a full valid potential Yevamot. And if she returns to her first husband, the child from him is not a mamzer, right? That the child would not be a mamzer because that was technically her real husband. And the second relationship had no legal standing vis-a-vis her relationship with the first husband. Yes, it may be that we would want her to divorce, but if they had a child, it would not be a forbidden relationship as though it were a form of adultery to the second husband. All these halachot refer to a situation when she married with the permission of the court after hearing that her husband had died. But if she married without the consent of the court, basing herself entirely on the testimony she heard, and her husband returned, it is permitted for her to return to her first husband. Okay, so this last stipulation, right, is that because this is a genuine circumstance of beyond her control, right, then this is a complete mess, and therefore she should be allowed to return. Now, Rabbi Shimon, like Rabbi Elazar and Rabbi Yossi, loses all of these points, right? That no, that is not the way it works. That we see this as being a blanket statement, and their stipulations are not upheld. Again, if you want to learn more about that argument and how it plays out, that's when we're going to be getting to the Talmud someday. The Mishnah adds another difference between these two scenarios. If she married by permission of the court, she must leave both of them, and she is exempt from the bringing of an offering. Now, the bringing of the offering means the sin offering for her unwitting adultery, as she had authorization of the court and is therefore considered to have acted under duress. And we're going to talk more about that idea of permission or no permission and the offerings in Mishnah 2. Okay, I can get it on one page. It's relatively short compared to the marathon Mishnah of number 1. All right, so Mishnah 2. If, however, she did not marry by permission of the court, she must leave her second husband and is liable to bring a sin offering for mistakenly having relations with a man forbidden to her. In this regard, the power of the court is greater, as she is exempt from bringing an offering. So the issue here is that if there is a court that is in error, if the court makes a mistaken ruling, then the court is liable, as we learned about in the beginning of the book of Vayikra, the book of Leviticus. But the person who was just following the court's instruction is not individually liable. Let's take a more mundane example. If a Beit Din examines a piece of meat and declares it to be kosher, and you eat that piece of meat because the court said it was kosher, and then you find out later, and the court finds out later, that they made a mistake, for whatever reason, all three of them were in error, you, the person who ate ate the meat, are not liable for a sin offering for your slip up, for doing this as an accident. The court, on the other, does have an offering that it must bring, because the one who made the mistake, then that technically takes it out of her hand. Now, just as a little bit of a insight into the Gemara, again, I keep going into it because I know that many of you are very interested in the long-term implications of this. When the Gemara examines this, they actually say that what's happening here is not what appears, that in fact the court this would not be exempting the sin offering because of the power of the court, because this is in fact a completely erroneous ruling of the court, and therefore the court cannot give permission for a person to commit that error, and therefore the error is still on the shoulders of the individual. For example, in another case, if a court was to tell you that it's okay to eat bacon, and you go out and eat bacon, that does not mean that you're off the hook for eating the bacon, because it is obviously an error and not a mistaken ruling, and therefore you are not off the hook just because you're relying upon the court.
Rabbi.
Yes.
And I know there's probably not a distinguishment here. So there's no distinguishment between mistakes of fact and mistakes of law?
Ish. But it's complicated, and someday we'll go through some of those types of rulings. But there are errors that are so obviously errors, both of the law as well as the fact, that they invalidate the ruling as a ruling. And then there are errors that are both of fact or of law that cannot invalidate a ruling, because it is possible to see how the mistake was made. But it's complicated, like any good legal system should be.
But wouldn't one of these pretty much be easy to see how the mistake is made? I mean, you have testimony of one person, you either believe them or you don't. If you believe them, you have a mistake.
Correct. But the repercussions of permitting a married woman to marry another man are so severe that they are putting up additional barriers to say that a person cannot be perfectly exonerated under this type of circumstance. But like I said, that's why it's discussed in much more detail in the Talmud. The second half of this Mishnah, if the court instructed her to marry on the basis of inaccurate testimony, and she went and ruined herself by engaging in licentious relations outside matrimony, she is liable to bring an offering as they permitted her only to marry and not to engage in licentious relations. So this is saying just because the court said, even though it was a mistake, that she could get remarried, that does not mean that she is allowed to go around and have other relationships that are invalid in and of themselves, whether that be licentious or, as some other commentators point out, for example, if she were to marry a Kohen, which as in this case, she would not be allowed to do. So permission to remarry is not permission to fool around, is what this last part is saying. Okay, let's move on to Mishnah 3, where we are now going to deal with Yibum and death overseas and see how this works together. And of course, more mistakes. With regard to a woman whose husband and child went overseas, and witnesses came and said to her, your husband died, and afterward your child died. Right? So I was watching, and the bandits killed your husband, and then they killed your daughter, your son. She does not require levirate marriage, as she had a child when her husband died. Right? Because the child died second, it meant that at the time of the husband's death, even if it was only separated by a few minutes, he still had a kid. And therefore, levirate marriage was not needed, even though a few minutes later, he doesn't have a kid. It's only the status of him versus and relation to children at the time of his death, not permanently, right? Or else Yibum would always be a potential problem. And for this reason, she married another man, right? She went and got married. She didn't have to do Yibum. She didn't have to do Chalitza. So she was just a regular widow, and she went and got remarried. And if afterward they said to her that the matters were reversed, oops, that the child died before the husband, which means she did require levirate marriage, she is therefore a Yevamot who married a stranger without Chalitza, and she must consequently leave her second husband. That second marriage is invalid because she was supposed to do Chalitza or have a levirate marriage with one of her brothers-in-law. And since she didn't, even though it was on the basis of what she thought was testimony, she is then not allowed to remain married to that second husband. And with regard to the first child, meaning the one born before they heard about the reversal, and the last one, meaning any child born after they realized who actually died first, each of these children is a mamzer, born from an illegitimate relationship. Conversely, let's do the opposite. If they said to her, your child died, and afterwards your husband died, and she therefore entered into levirate marriage, and afterwards they said to her that matters were reversed, which means she married her husband's brother when there was no obligation of levirate marriage, which, remember, you're not supposed to marry your brother's sister, she must leave her husband. And the first child and the last one, meaning before they learned and after they learned, are each a mamzer because it is a forbidden relationship.
But it's not her fault. I know that the rabbi like white and black, but come on, that you are destroying the life of the woman, the son, the new sons or children, when it's not their fault. It was a mistake for the people that came with the news.
All right,
she
so
doesn't have any way to double check who was killed first.
So you're right and you're wrong, right? So first of all, the rabbis do not like black and white. If they liked black or white, we would have been done a long time ago, because they would have just said, when the husband dies and we don't know what happened, you never get married again. You are now in mourning for the rest of your life, and you wear black and a veil, and that's it. And there are some countries and communities where that is the culture. Or if the husband died and you want to get, and you got a testimony that he died, you want to get remarried, fine, go ahead, do whatever you want. And if he shows up again, doesn't matter. The law declared him dead. We don't have to worry about this. Indeed, that's the way American law handles most of this situation. That once a person has been declared legally dead, we're done. Judaism says, nah, it's complicated, right? Depending upon what information you got, depending upon how you handle the information, and depending upon what the real situation was, well, we're going to spend a few hours at least talking about this in order to try and negotiate what the true outcome should be. Now, the result, as you say, feels very black and white, that it is harming in many ways the people who did not necessarily set about to do anything wrong. But the fact remains that something wrong did happen. And that is why this situation is so fraught with peril. That a person can act with the best of intentions, and they can act on the best information they have, but still create a problematic situation. And those good intentions, while they will certainly help us feel good feelings towards the people, don't change the facts of the case. They don't actually change that she had a illegitimate relationship. The intention notwithstanding, the relationship was an illegitimate one. Similarly, if a person is cleaning a gun and it goes off and they shoot someone, yes, that's not murder, but somebody is dead. And the fact that it was an accident will certainly change how we handle some details, but it's not going to change the fact that the person is dead. And in this particular case, it's not going to change the fact that it was technically adultery or an illegitimate relationship with the brother-in-law, and that is inappropriate, even if it wasn't intentionally done as an inappropriate action. I will remind you that our tradition goes to great lengths to find other ways to untangle the problems that are happening here, whether it be a retroactive divorce or annulment of the marriage, in order to prevent this type of problem. And in fact, it was common for men that were going on trips to leave a conditional get. And that's a big part of the Masechet Gittin when we eventually get there, is the husband will leave a get that says, if I'm not back in a month, in a year, in 2 years, whatever would be the condition, then this is your get from today. So if a witness shows up and says he died, and then he shows up later, but it's after the expiration date of the get, it doesn't matter, because technically they were divorced retroactively, and so there's no problem. So knowing that this is the outcome, our tradition has found ways to avoid the outcome that don't involve just pretending like it didn't happen. But instead, it involves a little bit of pre-planning and a little bit of more creative judicial involvement, but not pretending like adultery didn't happen when it clearly did. All right, let's press on, because I definitely want to finish at least this Mishnah. Your child, you must leave them on. Right. If they said to her, your husband died and she married, and afterwards they said to her that he was alive at the time of the marriage, then and later he died, right? So she got information that he was dead and she married, and then she found out he wasn't dead when she was first told, but she is dead, but he was dead now, that he was dead later, right? So his death is correct, but where on the timeline was wrong. She must leave the second husband, right? Because technically that was adultery. And the first child, meaning the child born when her original husband was still alive, based off that first report, is a mamzer. And the last one, meaning the child born after his actual death, which was at some point during her second marriage, is not a mamzer, because he was technically dead at that point, and although she is not married to the second husband because she couldn't have gotten married to him by the first ceremony because the first husband was still alive, a child born out of wedlock in Jewish law is not a mamzer. Right? That's a very big difference, as I've mentioned before, between Jewish law and Western European law. That born out of wedlock is no great honor, but it also is not the same as the English legal term bastard. If they said to her, your husband died and she became betrothed to another, I mean, remember, betrothing is a serious commitment. It's not just a casual engagement like many people engage in today. And afterwards her husband came, she is permitted to return to him, the first husband, as betrothal alone does not render her forbidden to her husband. Right? A betrothal, yes, is not the best thing to do when you're already married to someone else, but because they didn't consummate and conclude with an actual marriage, she is allowed to return to that first husband when he shows up and is still alive. Furthermore, although the last man, meaning the engaged betrothed, gave her a bill of divorce, a get, he has not thereby disqualified her from marrying into the priesthood. Right? She isn't technically divorced. She was never his wife, for the betrothal was invalid, and the bill of divorce given to the wife of another man does not disqualify her. Right? If I write a get saying that I divorce some woman that I'm not married to, that does not make her a divorcee who is not eligible to marry a Kohen. So she would retain her status as being a non-divorced woman. Now, if the first husband wants to divorce her, that changes it, of course. And this would be, of course, the condition would be for the marriage to the Kohen would be if the first husband died, leaving her a widow, which a Kohen is allowed to marry, not a Kohen Gadol, but a regular Kohen. She would not have the status of divorcee, despite if she had been given a divorce by that second husband. All right, one last summary. This was taught by Rabbi Elazar ben Matya. The verse states with regard to priests, neither shall they take a woman divorced from her husband, which indicates, and not one who was divorced from a man who is not her husband, meaning the second man in this case. It's not about having a get. It's not just because she was given a divorce document. It's only if her actual legitimate husband divorced her that she is then disqualified from marrying into the priesthood, which I think most of us would consider to be a very legitimate reading of the details of that verse. Any questions from Mishnah 3? All right, we are going to leave it there because Mishnah 4 is going to turn the tables. Now it is the woman who is going overseas, and with reports of her death being greatly exaggerated. So we're going to deal with the alternative version next Wednesday. Everybody hopefully realizes that as the sun is getting close to setting, that we are coming up on Yom HaAtzmaut, Israel's Independence Day. So let's make sure that we celebrate this wonderful day of Israel's 73rd birthday, and hope that she has many more and that they only get better and more peaceful and safe for everyone.
Amen. Rabbi, one question was reading
Yes.
again. The last example, the last case when someone said to her, your husband died and she was betrothed.
Yes.
And after that, the husband came. She's allowed to come back to the husband,
Yes.
but she doesn't receive any ketubah, nothing from the second one.
Correct.
Okay.
Correct. It's like it never happened.
Okay.
He never gets a ketubah from the second one, right?
No.
She never gets a ketubah under any circumstances from the second one. Correct. Because the second one was definitely a fake marriage in all ways.
And she wouldn't get a ketubah from the first one either, would she? Because this would be adultery.
Well, no. Remember, this is the final case is when she was only betrothed.
Betrothed, but then she's not divorced, so.
Well, no, no divorce is technically needed because the betrothal itself is also invalid. You can't legally betroth someone else's wife.
Right, but with the first one, he won't have to pay the ketubah because there's no divorce yet, right?
Right, but there's no ketubah to pay because she's still his. She is still his wife. They're still, well, hopefully happily married, and she is counting her blessings that she didn't get married to the other guy when her husband was really still alive. So this one we can call a happy ending.
Yeah. Question, Rabbi, not related on that. I was studying today something and will not take more than 1 minute, promise. What is your definition for Reshut Rabim? Because they are saying there that 600,000 people, okay, they need to pass through there. But how many places in the old Israel they had 600,000 people passing through there? So they didn't have any Reshut Rabim. What is the definition for Reshut Rabim?
So no, that is the definition. But the issue was that the rabbis, like we've talked about when we were studying Masechet Eruvin, they both wanted to restrict carrying, but they also wanted to leave open permission to allow the building of Eruvin that would allow for carrying under certain circumstances. And a full Reshut HaRabim would prevent that in many places. And so they wanted to limit that definition so that it wouldn't be too widely used.
So and how they limited that?
So it was the rabbis made a stringency and then made a deliberate limitation to the stringency to allow leniency.
In English?
They're having their cake and eating it too. They wanted to make sure that people didn't carry.
No, I know, but how, using which tool?
So they instituted a stricter definition of carrying than an average person might have interpreted from the Torah directly. But having done so, they then defined the terms of public and private domains in a way that would allow the creation of an eruv that would permit carrying under many circumstances.
Okay. You know what? Eruvin was still very difficult.
Eruvin is where a lot of people give up their Talmud study if they're going in order. That's why traditionally you don't start there.
Yeah, that is right. Thank you, Rabbi, for the shiur. Yasher koach.
Thank you, and to all of you, have a wonderful night and enjoy Yom HaAtzmaut.
Thank you.